Hello and welcome dear students to Narayana IS. I am Pratik, your faculty for Polity, International Relations and Internal Security. Students, in our previous session we covered 9 crucial topics that are highly relevant for the UPSC CSE Prelims examination. I sincerely hope that you not only understood those concepts but also have taken the time to revise them thoroughly using the link of the notes provided in the description box. Today, we move ahead with even more enthusiasm as we dive into 10 important topics that are equally significant for your preparation. Remember, this Prelims Masterclass is specially designed to strengthen your hold on current affairs across all the subjects relevant to the Prelims examination. The content that we generated is crisp, exam oriented and absolutely free of cost, so make sure you make the most of it. Also, students, I request you all to share this initiative with your friends and fellow aspirants appearing for this year's examination. Let us ensure that every sincere and deserving student get access to this enriching content without any barriers. Before we begin, make sure you're fresh, focused, and ready with your pen and notebooks so that you can jot down the important points and don't just be a passive listener. With that, let's kick off today's session with and move on a step closer to cracking the UPSC examination with confidence. Let us begin. And before we discuss the topics that we shall be discussing today, let me take this opportunity to introduce Narayana IS upcoming program. Soon we are going to launch 1 year and 2 year program. 1 year program specially for students who will be appearing the examination next year 2026, and those students who plan to appear in the year 2027. We have a 2 year, so we have 1 year and 2 year integrated prelims come mains preparation, right? So students, if you are interested to enroll in these two programs, make sure you're scanning the QR code that you can see on your screen. Fill in all the necessary details and then our team shall get back to you. Here you can see the detailed program or detailed features of our program. You can also visit our website in order to more information, in order to seek more information about the program. Right? Make sure you fill in the required details and then our team shall get back to you. Right? Each and everything required for you to clear the examination will be provided here at Narayana, be it from mentorship, be it from motivating students, for which we call the retired bureaucrats, as well as the serving bureaucrats, then your faculties, then your mentors who are always there with you. Any problem that you come across, our team is always there with you. So make sure you enroll in either of the programs and ensure that you clear the examination, and so that you contribute to the growth of a nation. That is very, very important, right? So on this note, let us start. So these are the 10 topics that we shall be discussing. The first topic will understand what is inner line permit. The second, what is criminal defamation and how it is different from civil defamation. The third article is right against climate change, which has been included as part of fundamental rights. The fourth, status of right to property. Right to property, is it a fundamental right, constitutional right, legal right? Then we'll understand about the concept of OBC creamy layer. Then we'll understand what is detention, what is preventive and punitive detention. In the seventh topic, we shall focus on what exactly constitutes enemy property. The eighth topic, right to be forgotten. Ninth, right to adopt child. And 10th is the overseas citizens of India. So these are the 10 topics that we shall be discussing today. Let us start with the first topic, that is the inner line permit. And what is the context? The context being that the Nagaland government has recently implemented inner line permit in few districts in the state. Why? The purpose was to address the concern of illegal migrants. The purpose was to deal with the crisis of illegal migrants. That's the reason ILP was introduced in the state of Manipur. Sorry, my by its Nagaland. But first and foremost, why are we discussing this topic? Because questions on this topic or surrounding this topic have been asked in the examination, like it was asked in the year 2019 on the 5th and the 6th schedule of the Indian Constitution. Right? So the 5th schedule deals with the scheduled areas, the 6th schedule deals with the tribal areas in 4 states of Northeast. So in yesterday's lecture, we discussed the 4 states that fall under the 6th schedule. So which are the 4 states? One is Assam, Meghalaya, Tripura and Mizoram. These are the 4 states that fall under 6th schedule. Right? So first and foremost, let us try to understand what exactly is inner line permit. Now the inner line permit is nothing but it is an official travel document. It is a document. It is issued by the state government. Another important point for your prelims examination. So in the examination, they may confuse you with the statement asking inner line permit is issued by the, let's say, local government, or let's say the central government, the home minister. It's incorrect. Why? What is the purpose? That allows entry into certain protected or restricted areas of India, which means there are certain protected and restricted areas in our country, and in order to enter those areas you need to seek permission. For example, tomorrow, let's say I want to travel to Maharashtra, or let's say Andhra Pradesh, Tamil Nadu, right? I am free to travel, but there are certain areas, especially in India's northeast, where you need to seek permission from the state government. You may wonder, what is the purpose? What is the purpose of issuing ILP? See, the purpose of issuing ILP is to regulate the movement of non-residents into the areas that are ethnically and culturally sensitive. Ethnically and culturally sensitive, which means these are the areas which are inhabited by the indigenous tribal populations. This ILP ensures that the demographic and the cultural composition of the region, these protected areas, preserved, and the traditional rights of these tribal communities is also protected, which means the non-residents should not affect the rights of the indigenous tribal communities. These tribal communities are given protection under the ILP 6th schedule. We discussed about the 6th schedule in yesterday's lecture. Please go through the lectures, through the notes and revise. I hope you understand the concept of ILP. ILP is nothing but in order to seek or give protection to certain indigenous tribal communities. ILP is issued by the state government, so that the purpose is that the non-residents should not enter into those areas and establish, let's say, their houses or homes or buy land and properties in those areas. This is to protect the tribal culture, their cultural rights, traditional rights over the land. I hope you understood what is ILP. Now, let us try to understand the origin and the legal basis. Now, please remember that the origin, right? The origin of ILP can be traced to the Bengal Eastern Frontier Regulation of 1873. This predates the independence. It was introduced by the British as part of their isolationist policy. Isolationist policy for the northeastern region. Now, this was applicable to the present Arunachal Pradesh. Now, under section 2 of this act, right, this law, the inner line was established, beyond which entry of outsiders was restricted. So, inner line was established, the outsiders cannot enter. Section 4 it provided for the issuance of permits for temporary entry and residence, for temporary, or let's say for some time, for a short duration. Through the issuance of permits, people can enter into those protected areas. Now, initially the restrictions were applicable to the British subjects, but post-independence it is applicable to the citizens of India. It is applicable to the citizens of India. So, this is, you need to also trace or know the origin of the ILP. So, isolationist, what does it mean? Which means the British did not want the northeastern people to know about the independence movement in our country. They wanted the northeastern tribal people to stay away from the independence movement. That's the reason. So under the guise to protect their culture, they actually isolated India's northeastern population from the rest of India. I hope you got the concept. Now talking about the applicability, the geographical applicability of this system. Now, the ILP system is currently in force in 3 states, which are Arunachal Pradesh, Nagaland and Mizoram. Again, a very important point for your prelims. You have to remember these points. So, make sure you remember these points, which means the citizens of India, they need a permit to travel to these 3 states. The foreigners, they require a different permit. So, this is citizens and the foreigners, they require different permits or different permissions to enter these states. Now, let us also try to discuss the types of areas. One is the protected areas, the other one is restricted areas. First, we shall discuss about the protected areas. Now, the protected areas, which means the protected areas lie between the inner line and the international boundary. Inner line and the international boundary. Now, please remember that these protected areas are designated for strategic and security reasons. For strategic and security reasons, right? Why? Because they lie close to the international boundaries. They require protection area, protected or protection area permit. People require protection area permit, or this permit is applicable here. And both the foreign nationals and in some case the Indian citizens, right, they require permission to enter these zones. This area may include, let's say, the border districts or villages in states like Arunachal Pradesh, Sikkim, parts of Himachal Pradesh, Jammu and Kashmir, Uttarakhand, Andaman and Nicobar Islands, because these states, they border the international countries. So the regulation, which regulation? The protected areas or the permit that is required to enter these areas. The purpose is to help prevent unauthorized movement, to ensure that our country is secure, that is for the purpose of national security, and also to monitor the bordering regions which are very sensitive. So this is the protected areas. They lie between the inner line and the international boundaries. So again, important point for you to remember. The next is the restricted areas. Now, restricted areas are those that lie between inner line and the indigenous tribal areas. Inner line and the indigenous tribal areas, especially in the northeastern states. Now, these areas are protected primarily for cultural and demographic preservation. For cultural and demographic preservation, which means this is meant to protect the indigenous tribal groups in India's northeastern state. Again, this restricted areas permit. This system is used to regulate the entry of foreign nationals as well as the Indian citizens, which means people need a permit to enter these areas. Why? Because we know that the restricted areas, they are home to the indigenous tribal group, and the goal of this restriction is to protect their culture, the social culture, let's say their traditional rights over the land. so as to control the influence of outsiders in the tribal region. Again, purpose of the ILP, we have discussed to preserve the indigenous identity, that is, the outside influence should not interfere with the demography of the region, to prevent influx and exploitation. For example, many regions in India's northeast have been disturbed demographically because of the influx of the illegal migrants from Bangladesh, and also to safeguard the local laws. Now, these local laws are actually based on the customs traditions of local tribal groups, and who needs an ILP? The Indian as well as the foreign tourists. We have just discussed that these are the two category of people that require ILP. I hope you have understood what exactly is ILP and what it stands for, and who are the people that require ILP. So please remember that the ILP does not grant any residence or property rights. It merely allows temporary entry. Now, this system is actually a constitutional mechanism, right, used to balance one, national integration with the cultural preservation of the sensitive border areas, especially those sensitive border areas having higher concentration of tribal population. So I hope you understood the first topic. Let us move on to the second chapter, second topic. It talks about criminal defamation. Now, the 22nd Law Commission has recently recommended that criminal defamation should continue to remain a part of India's criminal legal framework. Now, this recommendation given by the Law Commission has reignited the passionate debate on whether criminal defamation should exist in a democratic society as ours, because the democratic societies, they often protect freedom of speech. So, is it feasible to include criminal defamation in a democratic society as India? Why? Because here we are saying that we protect your freedom of speech, and on the other hand, you're also punishing people. First and foremost, let us try to understand what exactly is defamation, what is criminal defamation, how it is different from civil defamation. Now, this topic is important because questions on defamation have been asked in the examination. For example, if you see, okay, so this question is not directly related with the topic, but questions on, because there were many issues surrounding the issue or surrounding the topic of defamation. So questions are expected in this year's prelims examination. So make sure you have a decent understanding of the topic on defamation, right? Now, what exactly is defamation? This is something that you need to understand. What exactly is defamation? Now, defamation refers to any act where a person's reputation, your or mine reputation, is harmed. Respect is harmed through the use of words, signs, or visual representations, whether spoken or published. Let's say when someone is speaking bad about me, or let's say abusing me, this is actually harming my reputation, right? So this harm must be considered or must be caused with intent or with knowledge that such harm is likely to occur. This harm, the harm that is actually that harm that results in the violation of, let's say, a person's respect. Now, please remember that Section 499 of the IPC. Now, IPC later on got replaced by the Bharatiya Nyaya Sanhita. It defines defamation in legal terms. So, BNS, Bharatiya Nyaya Sanhita, it defines defamation in legal terms. Now, as per the BNS, defamation, right, is considered a criminal offense only when the imputation is made with a malicious intent or gross negligence resulting in damage to a person's reputation. So this and this means the same, which means let's say someone is abusing me, which is harming my reputation. This amounts to defamation. This results in damage to a person's reputation. Now there are exceptions to the BNF as well. Now, which are the exceptions? For example, statements made in public interest. Let's say, for example, I am criticizing the Prime Minister of our country. I am criticizing the, let's say, the President of India, but the criticism is in public interest. Let's say I am exposing the scam done by the Prime Minister, or let's say the President, or let's say any minister. If it is in public interest, though it is harming the reputation of the Prime Minister or important personality, but it is in the public interest. Then comments on the public conduct of public officials like the President, Prime Minister, remarks or opinions made in the context of public questions, critics of public performances such as art or literature made in good faith. So let's say if you are criticizing a song, criticizing a movie, so these are the exemptions under section 499 of the Bharatiya Nyaya Samhita. So these exceptions they are actually preserving or protecting the free speech under Article 19 of the Indian Constitution. Now let me first explain the difference between criminal defamation and civil defamation. Now please remember, civil defamation. Let's discuss first what is civil defamation. Well, civil defamation is when a person files a case to get compensation for damage to their reputation. They are filing a case why to get compensation. It is considered a private wrong under the tort law, under the law of tort. The person affected, which means let's say I am affected, I am referred to as plaintiff. A person whose rights are violated is referred to as plaintiff. So whenever I am filing a case, that is a plaintiff is plaintiff. One who files a case. Why? Because his reputation is damaged. So this plaintiff must prove what he must prove, that false and harmful statements were made about the person, about the plaintiff. The punishment in civil defamation is usually monetary compensation. It can also be settled out of court. This is what is referred to as civil defamation. The purpose is compensation, usually monetary. But criminal defamation is different. Here you need to understand the difference, because questions can be asked on the difference between civil and criminal defamation. Now, criminal defamation on the other hand, right, which is mentioned under section 499 and 500 of the IPC, now BNS. Now, in this case, the affected person can file a criminal complaint. And let's say I am filing a criminal complaint on a person, and if the other person is held guilty, then punishment up to 2 years in jail or a fine is imposed by the judiciary. Which means the complainant, the person who is making a complaint, has to prove that the accused, the person against whom I am filing a case, the purpose of his statement was to harm my reputation. And this must be proved beyond reasonable doubt. In this case, we discussed that it can also be settled out of court, but here it cannot be easily withdrawn or settled without the approval of court. Here, once a case is filed, you can also settle outside the court, but here, once a case is filed, you cannot withdraw without the approval of the court. So, in short, please remember that civil defamation focuses on compensation, usually monetary compensation, while the criminal defamation is about punishment for hurting someone's reputation. So, this includes fine or a jail term up to 2 years. Again, the punishment Again, you do not have to remember exactly the punishment, but please remember punishment is also awarded in cases of criminal defamation. Cases of criminal defamation. Also remember that under the newly constituted BNS, community service has been added as an additional form of punishment. So punishment doesn't mean that a person has to undergo hard labor or let's say rigorous imprisonment. The government can also, let's say the court can also award or force a person to do community service. Why? Offering a reform oriented approach. By let's say working for the community, the state is actually giving an opportunity to the guilty person to reform, to rectify his mistakes. But here in the context we discussed that the law commission, what did the law commission say? That the criminal defamation should be continued. The law commission, right, it observed that the reputation is a vital part of article 21 of the Indian Constitution. 21, it talks about right to life and personal liberty. Therefore, freedom of speech under Article 19, Clause 1, subsection A must not come at the cost of another person's dignity or reputation. My freedom of speech does not allow me to harm the reputation of other person. The commission actually justified criminal defamation as a necessary legal safeguard to protect the dignity and freedom of individuals. The Law Commission also referred to Article 19, Clause 2 of the Indian Constitution, which allows a state. This article, Clause 2 of the Indian Constitution, allows the state to place reasonable restrictions on freedom of speech. Which means having freedom of speech does not mean that you abuse a person or let's say you completely harm, denigrate a person to the extent that he feels inferior about himself or herself. Let's say, for example, having the freedom of speech does not mean that you are criticizing a person based on his caste. Then so which are the restrictions? Restrictions include, for example, public order. I think so. Few of the restrictions under Article 19(2), it includes public order, decency, national security. Now, having the freedom, having the right to speech does not allow you to speak against the security of a country. Against, let's say, if you're saying something that can actually cause a disturbance in the public, then action can be taken against you. So the commission emphasized that speech should only be criminalized, which means freedom of speech should be curbed, should be criminalized only when it causes substantial harm. If you are offering genuine criticism, no one can take any action against you. Of course, this is in letter, but in practice, we often see that all the governments have targeted the journalists who have spoken against the interests of the government. So to support the argument of the Law Commission, which stated that criminal defamation should be continued, it actually cited a report of the Organization for Security and Cooperation in Europe. This organization found that 42 out of 57 member countries have criminal defamation provisions in one form or the other. So it justified the continued use of criminal defamation. I hope you understood what the Law Commission observed about criminal defamation. Now let us try to understand the observation made by the Supreme Court in the Subramaniam Swamy case versus Union of India in the year 2016. The case questioned whether criminal defamation violates the Indian Constitution, and the Supreme Court upheld the constitutionality of criminal defamation, stating it falls within the scope of reasonable restriction under Article 19, Clause 2. It said that yes, criminal defamation is required. The court asserted what it did say. It said that refutation is not only a fundamental right but also a human right. Since the society is made up of individuals, protecting their reputation helps in preserving the overall dignity and also to ensure that there is harmony in the society. Therefore, defamation can be considered a public wrong justifying the recommendation made by the Law Commission to continue its use. So, defamation, yes, is considered as public wrong when it is causing substantial harm. That's the reason, yes, in a democratic society, in order to protect the rights of others, it is important that we have criminal defamation clause or provision in our, let's say, legal framework. But again, care has to be taken so as to ensure to not misuse the provision, especially by the government, to target the opposition. This is what we see the governments of all the countries, or let's say government of our country, doing it so. So we need to ensure that we have to avoid misusing the criminal defamation provisions. So all in all, you need to understand that the criminal defamation continues to be a legally and, let's say, constitutionally approved provision in our constitution or in our country. The law, what it does, it aims to safeguard the individual's reputation. Again, care has to be taken so as to ensure that it is applied carefully and does not harm or does not suppress criticism or the right to free speech. And that's the reason the recent recommendation of the Law of Commission, should be continued. I hope you understood the second topic as well. Let us move on to the third topic now. The third topic, title of the third topic is Right Against Climate Change. Here the Supreme Court recently held that citizens have a constitutional right. Please see, such terms are very, very important for you to remember. These are the words that the UPSC can twist and ask you questions. The Supreme Court held that the Indian citizens have constitutional rights to be protected from the adverse effects of climate change. We have the constitutional right. This judgment of the Supreme Court, it marks a very, very important step in recognizing environmental protection as an integral part of fundamental rights, which essentially means that this judgment has expanded the scope of fundamental rights to include environmental rights as well. This is a landmark judgment given by the Supreme Court in the M.K. Ranjit Singh and others versus Union of India case in the year 2024. Right? Now, let's try to understand the background of these stories. So the petition originally filed in the year 2020 by the experts in the field of environment. They challenged the construction of overground power lines in Gujarat and Rajasthan. So the government of Gujarat and Rajasthan were constructing, or let's say were constructing power lines. So the petitioners argued that the overground power lines, they pose a serious threat to the great Indian bustard, a critically endangered bird species in our country. So this is what the petitioners had challenged in the Supreme Court. Now the Supreme Court in response, the Supreme Court had constituted a committee to examine the feasibility of underground power cables or underground power lanes and the installation of the bird diverters. So it constituted a committee to, let's say, to study alternate solution or option or feasibility. But the Supreme Court also addressed the core issue. The court expanded the scope of the case to include climate change related concerns. And this actually led to the landmark judgment given by the Supreme Court. So what did the Supreme Court say? Let's try to discuss. So again, see, question on the environment protection have been asked in the examination. So such topics are very, very important, right? So let us try to understand the observation made by the Supreme Court in the landmark judgment. The first one is right to life under Article 21. Now the court in the judgment observed that the right to life, which inherently includes the right to health, right to life also includes right to health. The Supreme Court said that this right to health cannot be fully realized without having the access to clean environment. And for a matter of fact, climate change directly threatens the right to health by affecting the, let's say, water and air quality. It also deteriorates the health conditions and affects the overall ecological balance. That's the reason the Supreme Court said that there's a direct connection that exists between the impacts of climate change and the, let's say, the deprivation of the right to life. So environment and life are connected. This is what the Supreme Court referred under the expanded meaning of Article 21. The Supreme Court also connected the right to environment, right to clean air with Article 14, which stands for equality, right to equality of the Indian Constitution. The court held that climate change does not affect all the populations equally. Article 14 says that each and everyone should be treated equally. But here the climate change is actually affecting the most vulnerable groups, especially the women and children. It is affecting the vulnerable groups. They are more severely impacted. Why? Because of, let's say, the social and economic conditions. For example, let's say in times of food and water scarcity, right? In times of food and water scarcity, the vulnerable groups, they bear a disproportionate burden of the crisis. And that's the reason, recognizing this challenge, the court actually linked climate change, climate justice to equality before the law under Article 14 of the Indian Constitution, thereby strengthening the principle that discriminatory outcomes caused by the, let's say, extreme climate or climate events must be addressed under Article 14 of the Indian Constitution too. And then the court actually rapped on the knuckles of the government to remind the government of their duty. The court, it made it very, very clear that it is not just the right of the citizens but also the right of the government to protect the people from the harmful effects of the climate change. And how? The government can formulate policies, can focus on the infrastructure development, and can also take preventive steps so that the people, especially the vulnerable people, are not affected by the extreme events happening because of climate change. Then let us also discuss the constitutional provisions on environment. First is Article 48 of the Indian Constitution, which is part of directive principle of state policy. It states that the state, Article 48, which falls under directive principles. What is directive principles? These are the principles that are directed towards the state, right, to work on implementing the policies mentioned under the chapter directive principles. So Article 14, Article 48 says that, or it directs the state, who the constitution makers have directed to the state to work hard, to endeavor to protect and improve the environment, and also protect the forest and the wildlife. Article 51, fundamental duty, which means fundamental duty of each and every citizen. What is the duty of every citizen? To make sure to protect and improve the natural environment. Now, natural environment, it consists of forests, lakes, rivers, wildlife. The purpose is to show compassion for the living creatures. So, are you showing compassion for the living creatures? Ask yourself. And make sure and also spread the information that it is the duty of each and every citizen to ensure that they are protecting the environment. So this judgment of the Supreme Court is a landmark in India's, let's say, environmental jurisprudence. So what the Supreme Court did is it connected the impacts of climate change with the fundamental rights. Very, very important. Which fundamental rights? Article 14 and 21. So here the Supreme Court not only expanded the scope of the constitutional protection but also placed A clear obligation, duty on the state as well as citizens to ensure that they are protecting the environment. I hope you understood the third topic as well. Let us move on to the fourth topic. The fourth topic is on the status of right to property in India. Now, the context being the Supreme Court recently reconfirmed that right to property remains a significant constitutional right and cannot be overridden arbitrarily by the state. The court clarified the government must follow due legal procedure before acquiring private property. A question on right to property has been directly asked in the examination. This was also in the news maybe like 3 to 4 months back. See, a right to property was asked in the year 2021. The question is, what is the position of right to property in India? Legal right available to citizens only, legal right available to any person, fundamental right, neither fundamental nor legal right. So this is how UPSC confuses. Let us try to understand the basics of right to property. What is okay? So let us try to understand what is the power of eminent domain. So we discussed yesterday that questions on political philosophies are asked in the examination. Now, such judicial principles are not mentioned in the statistics. As a reason, it is important to read newspaper, because only through newspaper you will come across such terms which are often asked in the examination. So what is the power of eminent domain? The power of eminent domain, right? It is the authority of the state. What? It is the authority of the state under the eminent domain. State has the authority. State has the authority to acquire private property. The state can also acquire my private property for public use. If there's no need for the state to require the or need the consent of the owner, but the state has to ensure that reasonable and fair compensation is given. Let's say it doesn't mean that I've invested my life savings to buy a property, now the state is taking it away. No, the state will provide me proper compensation. Again, here the Supreme Court refer that this power to acquire property is not absolute, which means the state cannot take away the private property arbitrarily, which means the state has to follow due procedure. Only then the state can acquire a private property. If the state acquires a private property without following due process, then the court can declare the action of the state unconstitutional. Now, which are the 7 guidelines the Supreme Court had made for the lawful acquisition of the private property? There are 7 safeguards the Supreme Court mentioned in the judgment, right? Guidelines to ensure that the rights of the private people whose property is taken away is not affected. The first one is right to notice. Now, under right to notice, the property owner must be informed in advance about the government's intention to acquire the property. Why? This right to notice is important to ensure there is transparency, which means it allows the owners or the owner of the property to be prepared. The next one is right to be heard. The owner must be given a, let's say, opportunity, reasonable opportunity to raise objections and prevent their viewpoint against the acquisition, which means the government has to listen to the objections raised by the petitioner or, let's say, owner. So the owner's voice should be heard. Right to a reasoned decision. The decision should be reasoned, should be backed by logic and rational, and it should not be arbitrary, which means the state must provide a clear explanation for acquiring the private property. Why the state is acquiring the private property? What is the rationale behind it? For which public purpose will the state use in the future? Then public purpose requirement. Here the state has to mention the exact reason the acquisition must be for legitimate public, purpose. Let's say for infrastructure, let's say for public utility, let's say for welfare schemes. And acquisition for private gain, or let's say if the state is acquiring for the personal interest of a minister, then such action can be declared unconstitutional. Right to fair compensation, that is money. The property owner is entitled to a fair compensation, which means the rate or the compensation that should be provided to the owner of property should be proportional to the market value of that property in that area, which means the owner should not bear any loss. And next, efficient process, which means due process. The acquisition should be carried out following all the legal process, and also it should happen in the time bound manner. There should be no unnecessary delays. And then the conclusion of proceedings, which essentially means that the acquisition process must result in the actual transfer of the possession to the state. If the government fails to take possession, the acquisition will remain invalid. The acquisition will remain invalid and also incomplete, which means the actual possession should happen on paper. This is what the Supreme Court, or this is how the Supreme Court gave guidelines to ensure that the rights of the owners whose property is taken away is protected. Now let us try to understand the status of right to property in the Indian Constitution. Now please remember, right to property was originally a fundamental right under Article 19 Clause 1 subsection F of the Indian Constitution. In the year 1978, that is through 44th Constitutional Amendment 1978, right to property ceased to exist as a fundamental right, which means right to property was made a constitutional right under Article 300A. What does Article 300A states? No person shall be deprived of his property taken away save by authority of law, which means a person's private property can only be taken away through a law, through a legal process, through a due process. This means the government can acquire property only through legal process and not in a whimsical manner. This is what Article 300A states, right? Right? I hope you understood the point, right? Now, please remember, although it is no longer, right, no longer a fundamental right, but the Supreme Court has recognized the right to property as a human right, especially in the democratic societies as India, which means interpreting right to property as human right, it actually imposes a limitation obligation on the state to ensure that whenever the state is acquiring private property, state has to ensure that the due process is followed, and only then the property can be taken away. I hope you understood this topic. Let us move on to the next topic. This topic is on the OBC creamy layer. What is the context? The context being that the recent allocation of an Indian Administrative Service position to Pooja Khedkar. So this a former officer who acquired IS through, let's say, fraudulent means, she actually applied as a OBC non-creamy layer candidate, right? And this actually brought renewed attention to the rules governing the creamy layer. So we know that the reservations are provided to the members of SC, ST and OBC community. And in OBC, we also have the creamy layer concept, which came into being in the famous Indira Sahni judgment. So we'll understand about this creamy layer concept. Now see, questions on reservation, right? Now this article actually pertains directly to Article 15 and 16. So question on reservation, Article 15 and 16 has been asked in the year 2023, just 1 year back, 2 years back, sorry. Let us try to understand the constitution and legal background of the topic before we understand the ongoing issue. Okay. So Article 15 and 16. Now see, Article 15 and 16 of the Indian Constitution, right? It ensures equality before the law, and it allows a state to make special provisions for the advancement of socially and educationally backward classes of citizens. And this includes the members of scheduled class, scheduled tribes, and the other backward classes. In the year 1980, the Mandal Commission recommended 27% to the reservation, which means the initial reservation was only confined, limited to the members of SC and ST only in the year 1980. Based on the recommendation of the Mandal Commission, reservation was also extended to the members of the OBCs in the central government jobs and the educational institutions. This recommendation was finally implemented in the year 1990. It was challenged in the Supreme Court and then the Supreme Court delivered a judgment in the famous Indira Sahni judgment of 1992, which means the Supreme Court upheld the reservation provided to the OBCs. Reservation provided to the OBCs in the year 1990 was challenged by the petitioners, but the Supreme Court said that yes, the reservation provided to the OBCs is constitutional. But it introduced a key condition. What is a key condition? That the economically affluent section, economically affluent section of citizens, that is people who belong to the creamy layer among the OBCs, should be excluded. This meant that the economically advanced and let's say the privileged individuals within the OBC should not be given any benefits of the reservation. This is what we understand by the concept of creamy layer, which means the people who are wealthier and who are advanced compared to the members of let's say SC and ST. This principle of creamy layer, it ensures that affirmative action is nothing but reservation. The people who are socially and educationally backward, the state is actually providing help in the form of reservation, and the purpose is to ensure that the purpose of reservation should be given to the intended beneficiaries. And what is the criteria for creamy layer? So let us discuss the criteria for determining the creamy layer. One, income criteria. Income criteria is very important, which essentially means that if the annual family income from all sources exceed rupees 8 lakh, the person is classified under the creamy layer and cannot, claim the benefits under the OBC reservation. This income limit is actually revised every 3 years. The last revision was done in the year 2017. Before 17, the limit was rupees 6 lakh. Now it was further increased to 8 lakhs because of simply the inflation happening in the society. So it is revised every 3 years. Next is the employment criteria, which means talking about let's say the group A officers, class 1 officers, which essentially means that if either parent is a group A or let's say class 1 officer in, it can be central government or let's say state government as well, which means the child of that parent who is working as a class 1 in the central or state government is not applicable to claim the benefit of reservation. Also talking about the class B or let's say class 2 officers, if both parents, in the earlier case it was either parent, here both the parents are let's say group B or class 2 officers, or let's say one parent is is in the group B and gets promoted to group A before the age of 40. Before the age of 40, then the applicant is also part of the creamy layer and will not get any benefit of reservation. Talking of the PSUs, that is the public sector undertaking. So if either parent holds a managerial position, deputy manager, general manager in a PSU. Not only PSU, let's say it can be insurance company, it can be a university, it can be an autonomous body. Then again, the children of those parents cannot claim the benefit under the OBC reservation. Talking about the constitutional position. So if either parent holds a constitutional position, let's say for member of parliament, member of the state assembly, president, governor, again the children of that parent cannot claim the benefits of reservation. And which are the additional considerations? Other income sources are also included. Other income sources. Now, under other income sources, besides salary, if the family's overall income, which includes, let's say, the the wealth, the rentals or business is above the limit of 8 lakh, then the people cannot cannot claim the benefit of reservation. Then we also have certain exemption, which means the agriculture income. The agriculture income, that is from farming or agriculture, the activities, is not accounted towards the 8 lakh annual limit set by the government. So these are certain criteria which you need to remember. This brings us to the end of this topic. Let us proceed, move on to the next topic. It talks about the rules for preventive detention. The Supreme Court recently ruled that the detainees, once who are detained, are referred to as detainees, must be provided with all relevant documents in a language they can understand. This upholds the constitutional right to personal liberty and fair representation. This judgment confirms the importance of procedural fairness, due process under preventive detention laws. So in this topic, it is important to understand the concept of detention, be it preventive detention or punitive detention. Now this is important because questions linked to this topic. So see, preventive or punitive detention is actually linked with the security of our nation, and that's the reason question linked to this topic was asked in the year 2023. That's the reason understanding such topic becomes important for not only the prelims examination but also for the mains examination. So what is preventive detention? It refers to the detention of a person before a crime is committed. Before a crime is committed, based on their belief that their actions could threaten public order or national security, which means here a person has not committed a crime. Please remember, person has not committed a crime, but there is a belief based on his recent action, based on what he's speaking, there's a belief that this person can actually cause public disturbance. This person can cause public disturbance, and that's the reason it is important that the government detain him, else this person may say something which can actually be very harmful to our national security. So please remember, preventive detention is not a punishment. Is not a punishment, but a measure to prevent potential harm, not only to him but also to the society at large. There are two types of detention. One is preventive, which means before a crime is committed, a person is detained so that this person should not do anything which can actually harm or cause disturbance in the society. The other form of detention is punitive detention, which means after a crime has been committed, the person is detained. Now this is a punishment. Why? Because a person has committed a crime and that's the reason he is being detained. What about the constitutional provision? Again, it falls under fundamental right under Article 22 of the Indian Constitution. So if you refer to Article 22, Clause 3 of the Indian Constitution, people who are detained under the preventive detention laws do not enjoy the same protection as those under ordinary arrest. So if you please open Lakshmikant's book and refer to the protection given to people who are arrested under ordinary arrest and under preventive detention, then you see the rights are different. The rights are different. So the usual safeguards given to a person who is arrested under ordinary arrest is mentioned under Article 21 Clause 1 and 22 Clause 2. For example, right to be informed of the reason for arrest, and let's say to also consult a legal practitioner. But a right to be informed or to allow to be defended by a legal practitioner, these rights are not given to people who are detained under the preventive detention law. Please remember this point. This is very important. Okay. So please remember the purpose, right? The purpose of preventive detention. It is to prevent a person from committing a crime which can be prejudicial or harmful to the state. The detention to detain is based on subjective satisfaction of the authorities which means the government. This actually concerns public security, public affairs, public order, foreign affairs, or let's say essential services. So this completely is subject to what the authorities or what the people in the government, think. So if you see here, in our country, preventive detention were introduced soon after independence with Sardar Patel, right, introducing the first Preventive Detention Act in 1950. Right, unlike many other countries, India has retained this laws. Many other countries, especially the democratic societies, have actually deleted this provision from their constitution. Other countries generally adopt such laws only under extreme circumstances such as war or national emergency. So in our country, it is not required to let's say to for a war or national emergency to be enforced only to invoke this provision. No, even without a declaration of war or national emergency, such provision can be invoked as it was invoked recently when Article 370 in the state of Jammu and Kashmir was revoked. Hundreds of people, hundreds of politicians were detained under preventive detention, which falls under Article 22 of the Indian Constitution. Objective, we have discussed what is the objective, right? Now, grounds for preventive detention. There are 4 grounds under which preventive detention can be imposed. 1, a person can be detained when he is causing a threat to the security of a state, when his action may disturb public order, maintenance of supplies and essential services, and defense. Let's say during, COVID-19, there are essential supplies which need to be supplied. Foreign affairs or security of state. If a person, let's say, may do something which can affect India's relationship with a country, then even then this provision can be invoked. This provision can be invoked. I hope you understood the 4 grounds. So this is important for you to remember. Now please remember, people who are detained under the preventive detention cannot claim protection under Article 19 and 21 of the Indian Constitution. 19 involves freedom of speech, freedom to move from one place to other, or let's say Article 21 deals with the right to life and personal liberty. Which means this actually makes preventive detention an extraordinary measure. Extraordinary measure. Is it constitutional? Yes, because it is mentioned in the Constitution. Simple. What are the constitutional safeguards? It also means that the government as per their own whims can invoke this provision and can detain anyone, isn't it? So there are some constitutional safeguards as well. Now, which are the constitutional safeguards? Detention limit. A person may detain, right, only for up to 3 months without review. How many? 3 months without review. Then talking about the advisory board review, right? Now to extend detention beyond 3 months. Once a person is detained, the government can detain him up to 3 months. It can be detained only after it is approved by the advisory board. Now this advisory board consists of members of High Court judges. High Court judges. Right to know grounds of detention. A person who has been detained has a right to be informed of the grounds for detention. However, if the government believes that disclosure or providing information can actually act or be against public interest, then the government can also withhold the information, which means the government can refrain from informing the person, the detained person, the reason why he has been detained. Then right to make representation, which essentially means that the person who has been detained, that is the detainee, must be given an opportunity to make a representation, that is to be defended by a legal practitioner. This actually again is a safeguard. Then exception for enemy aliens, which means these safeguards that we have discussed is not applicable to the enemy aliens, like for example the individuals, people from hostile aggressive nations like Pakistan, right? So these are the rules or constitutional safeguards. Now we'll discuss the judicial judgment, judicial ruling with respect to detention in our country. Now, first and foremost is the A.K. Gopalan case versus State of Madras in the year 1950, when this concept of preventive detention was challenged before the Supreme Court in this case. The Supreme Court actually upheld this preventive detention, right? Though it upheld the preventive detention, it actually also declared some of the provisions which were very, very arbitrary as unconstitutional. Then in the recent Jasila Shaji versus Union of India case in the year 2024, right? Here in this case, the detainee was not provided with a key witness statement and let's say a translation in his native language, which was Malayalam. The Supreme Court found this to be unconstitutional, or let's say violation of Article 22 of the Indian Constitution, which actually allows a person who is detained to be defended by a legal practitioner. Now, please remember that the detention of the person was made under the Conservation of Foreign Exchange and Prevention of Smuggling Activity Act 1974. It was initially upheld by the Kerala High Court. The detention was upheld by the Kerala High Court. However, the Supreme Court overturned the decision of the Kerala High Court due to the procedural lapses, which essentially means that, see, please remember, the preventive detention, right, is a powerful legal tool that must be exercised with caution. While it allows the state to take preemptive action for national interest, the Constitution provides safeguards to prevent its misuse. The Supreme Court, the way the Supreme Court emphasized on the procedural, let's say, fairness, such as providing documents in a way that should be understood by the detained person. It actually strengthens, reinforces the concept, the principle that liberty, freedom of a person cannot be curtailed, restricted without due process. I hope you understood this topic as well. Let us proceed towards the next topic, which discusses about the enemy property. The context being that Saif Ali Khan, a Bollywood actor, right, reportedly worth 15,000 crore. Saif Ali Khan's inheritance worth 15,000 crore has come under scrutiny due to the possible classification of a part of it as enemy property, which means the land which Saif Ali Khan, a Bollywood actor, inherits, a part of that land has been declared as enemy property. This has drawn attention to the legal framework and historical context surrounding enemy properties in India. Let us try to understand first and foremost enemy property. Right? What is enemy property? Now, enemy property refers to assets left in India by individuals who migrated to enemy nations. Enemy nations like Pakistan and China. During, we fought a war against Pakistan in the year 48, against China in the year 62, again with Pakistan in the year 65 and 71. Which means, let's say for example, an Indian citizen who migrated to Pakistan or let's say China during the wars. The property left behind by that person, the assets may belong to enemy subjects, enemy subject being the individual or let's say the company established by that individual who migrated to the enemy nation. The enemy properties, it also includes movable as well as the immovable assets such as land and the buildings. And the primary purpose, what is the primary purpose? The primary purpose of designating such territories, such properties as enemy properties to ensure national security by preventing enemies of the state from reclaiming or benefits from them, which means a person who has migrated to an enemy nation should not in future reclaim that property. This is the purpose, to secure national security. Custodian, who is in charge, let's say a person who has migrated to Pakistan, let's say China, who becomes the owner of his property? Now, under the Defense of India rules of 1962, these assets are vested in the custodian of enemy property for India, an authority appointed by the central government. So, this term central government, this Defense of India rules, it becomes important for you for your prelims examination, right? The custodian, which is appointed by the central government, is responsible for managing, preserving and disposing of these assets as per the legal provisions, which means the custodian is appointed by the central government. He is the one who decides what to do with the property. So, it is essentially the central government who actually is responsible, looks after the enemy property. Let's try to understand or see key facts about enemy properties. Now, as of Jan 2018, there were 9,280 enemy properties left behind by Pakistani nationals and 126 by Chinese nationals. So, if you come across a question, you do not have to mug up the number, but a basic understanding or a rough estimate is important to know, right? 9,280 enemy property left behind by Pakistan. In November 2018, the government approved the sale of enemy shares worth 3,000 crore. In 2020, a group of ministers led by the Ministry of Home Affairs began monitoring over 9,400 enemy properties valued at approximately 1 lakh crore. This is the amount to which the enemy properties is reported in the documents. Now, let us try to understand the legislative framework surrounding the enemy property. First, we have the Enemy Property Act of 1968. Now, this law declares that enemy properties will be permanently vested in the custodian and cannot be transferred. It cannot be transferred or inherited under the as per the Enemy Property Act of 1968. Then this Property Act was amended in the year 2017. Now, this is a very important amendment. This amendment actually further tightened the rules by expanding the bar on inheritance to include legal heirs and successors, irrespective of their citizenship status, which essentially means that, let's say a person has migrated to Pakistan or China, their legal heir or successor, they cannot claim their right on the property left behind by, let's say, their parents who actually migrated to an enemy nation, which means the property is left behind by a person who migrated to an enemy nation. Their heirs, legal heirs or successors cannot claim the right on the property left behind, even if their legal heirs or successors are Indian citizens, which means even Indian citizens cannot claim inheritance rights over the enemy properties. Now, let us try to understand this famous case. Actually, this case was in the news. That's the reason people started talking and debating about the enemy property. The Raja of Mahmudabad case of 2005. Now, in the year 2005, in the Raja of Mahmudabad case of 2005, the Supreme Court ruled that the son of this Raja, who was born and living in India and was having an Indian citizenship, has a right to inherit enemy property left behind by his father, even though his father had actually migrated to Pakistan after partition. The court treated the son as a lawful Indian citizen and allowed that this son can claim inheritance rights. As per this Amendment Act of 2017. So the court is giving a judgment in the year 2005. Government has amended this act in the year 2017. This amendment changed the law to say that no legal heir or successor, even if they are Indian citizens, can claim inheritance rights or inherit enemy property if the owner had migrated to an enemy country, be it Pakistan or China. This means that the 2017 amendment, it overturned the Supreme Court judgment which was made in the year 2005, which means it made all such inheritance claims invalid by law, which means a due process was followed. I hope you understood this case. And the recent development being recent changes, the 17th Amendment Act have included judicial clarification and structured procedures for valuation and disposal of enemy properties. Now, what about the enemy properties? How the enemy properties is to be disposed? These are the guidelines given by the government. You can quickly go through the guidelines, right? For example, valuation committees are formed to assess the financial value of enemy property. So these guidelines, again, they are self-explanatory. So I request you to please download the PDF and please go through these guidelines. Make sure, students, you are revising each and every point that we are discussing in the class. Make sure you are clicking on the link mentioned in the description box. The link will take you through to the application. Download the application, download the PDF, and make sure you are revising after the end of the lecture. By today itself, you should be in a position to revise the topics that we are discussing, because each and every topic point that we are discussing can be asked in the prelims examination, and you should be in a position to attempt the questions. The next topic to be discussed is the right to be forgotten. Now, the Supreme Court has recently agreed to examine whether right to be forgotten, interesting right, isn't it, which falls under the broader scope of privacy rights, can also apply to judicial orders, even though court records are traditionally treated as public documents. Now, this is an interesting topic. See, right to privacy was asked in the year 2021. As I told you yesterday, that questions on fundamental rights, fundamental duties, DPSPs are often asked in the examination. Given that this topic recently occurred in newspaper and across different media channels, there's a high chance, high probability that this question may be asked in this year's prelims paper. Now, first and foremost, let us try to understand what one understands by the term right to be forgotten. Now, right to be forgotten is also referred to as right to erasure. Now, right to erasure, it refers to individual's ability, my ability, to request the removal of their personal data from public platforms and search, such as search engines, databases, or websites. Let's say a legal case has been filed against me. Now the information is available in the public domain. Information is available in the public domain. Now, after some time, I want that the information pertaining to me, because it also pertains to my privacy, should be deleted from the search engine, so that whenever people search, they should not come across anything related to me. This is what understands by the term right to be forgotten. Now, the purpose of this right to be forgotten. What is the purpose? To protect personal privacy. Especially, this is important when the information is completely outdated or it is no longer relevant, or it can also potentially harm a person's reputation or dignity. This right to be forgotten, it lets a person stop the continued sharing, right? It stops a person stop the continued sharing of their data, especially if it stays online even after their original reason for posting is no longer valid. Please remember, there is no currently there is no specific, let's say, law or statutory backing for the right to be forgotten in India, which means there is no law in our country which allows a person that his data be erased from, let's say, the search engines of public platform. There is no legal mechanism, right? Yes, the Supreme Court or the Judiciary have discussed about this right, but please remember, this right has not been codified into law, has not been translated into law. Now let us try to understand. I hope you understood what is right to be forgotten. Okay, let me just give you an example to understand the importance of this right. Let's say, let's say I have been accused by XYZ person that I was actually involved in a robbery or theft, and the High Court actually convicted me, held me guilty. I appeal to the Supreme Court. Now the Supreme Court acquits me. Supreme Court declares that I was not involved in robbery. But the information that is available in the public platform is actually causing harm to my reputation. I have every right. Why? Because the Supreme Court has set me free. So I have every right to order the authorities to delete the information which is actually harming my reputation, be deleted from all the public platforms. But then this right is actually conflicting with the public record. How? The judicial orders and court documents are traditionally regarded as public records meant to uphold transparency and right to information. Now the students of law, they actually refer to the past cases and learn from the past cases. The judicial orders, they're meant to be open. They're regarded as public records, which means they're meant to be open. Each and every person should be in a position to access the data. This is actually meant to uphold transparency and also to have the right of information. But some people argue that allowing removal of such orders under right to be forgotten on the basis of individual privacy may violate Article 14 of the Indian Constitution, which guarantees equality before the law, as it might, create an example. It might create a precedent where only few people can access or have, let's say, access to this right to be forgotten. Now, this actually raises a very important constitutional dilemma, confusion of how to balance privacy rights. Every person has the right to maintain his data, or let's say he has a right of privacy, as was reaffirmed by the Supreme Court in the year 2017, the Puttaswamy judgment. Yes, with the public interest. Here it is important to see how to balance the privacy rights, which is very important for an individual, with that of public interest, so as to ensure transparency and accountability. So as to ensure transparency and accountability. Now let us try to see the Indian court rulings and how they were sort of different from the Supreme Court ruling. Now see, Okay. Now see, several high courts in our country have given different rulings on this right to be forgotten. Especially the Delhi High Court in the year 23 and 2021. Right? It allowed for the removal of an acquitted person, that is a person who was acquitted, from the search engine so as to protect the right of that individual, of that person. So the Delhi High Court, right? The Delhi High Court believed that continuing to show their names in the search engines, or let's say public platform, even after that person was not found guilty or a person was acquitted, could actually cause harm to the reputation of that person, which essentially violates his right to privacy. Then we have the ruling of Kerala High Court, which is actually contradictory to that given by the Delhi High Court. It said that right to be forgotten cannot override the principle of open justice. Very important. The principle of open justice, it stands paramount. And this right to be forgotten cannot override right to be, or cannot override the principle of open justice. It emphasizes that court judgments are traditionally public records and must remain accessible so as to ensure transparency. The Gujarat High Court in the year 2015. Now again, here you see the Gujarat High Court in the year 15, it supported the publication of full court judgments without, let's say, editing or even hiding the names of the people involved in the case. So you see here Delhi High Court is allowing a person that his information be deleted from the public platform, and then we have the Kerala High Court and the Gujarat High Court giving contradictory judgments as opposed to what the judgment was given by the Delhi High Court. But then the Supreme Court. What did the Supreme Court, the apex court of a country, had to say? The Supreme Court have addressed all such related concerns. Indian courts have generally permitted the removal of links from the search engines, which is called de-indexing. Indian courts have allowed de-indexing links and redacting names, that is deleting the names. But they have not allowed the complete removal. Make sure, to some extent, yes, the information can be deleted, but it's not something absolute. They are not allowed for the complete removal of the entire judgment from the public view. In the year 2021, the Madras High Court refused redaction, that is, the removal of the names. It argued that public has a right to know. However, the Supreme Court later on stayed the judgment given in the Madras High Court. It's the Supreme Court said that yes, in certain situation, information can be deleted, which means it actually linked it with the right to be forgotten. Right? So this is something very important judgment of the Supreme Court. Now please remember, the Supreme Court is still reviewing how to balance a person's right to privacy with the public's right to access the court records. So here it is very, very important for the courts, which essentially means that the Indian courts, as per the judgment of the Supreme Court said that yes, in certain situation, information can be deleted from the public platform. But the larger question that remains to be addressed is how to balance a person's right to privacy with that of the public interest, which is people should have the right to information. So this is yet to be seen how the court will in future deal with such cases, which actually is a conflict between a person's individual's right and public right. So here you see status in India. Right to be forgotten has been recognized as part of right to privacy under Article 21 of the Indian Constitution. Very, very important point for your prelims examination. Then as per the Digital Protection and Data Protection Act of 2023, the Act addresses data erasure but doesn't clarify if publicly available data is exempt, which means even the modern legislation is taking cognizance of the judgment given by the Supreme Court. Then the IT, that is the Intermediary Guidelines and Digital Media Ethics Code rules of 2021, allow complaints about unauthorized personal data exposure to be removed from the internet, which means there's a growing consensus, there's a growing debate about, yes, if there is a merit, then the information can also be deleted. If we can compare with the global perspective, the European Union's General Data Protection Regulation, the right to be forgotten is part of the right under Article 17 of the Indian Constitution. Right? So, this is something very important to remember. Let us move on to the next topic. The next topic talks about the right to adopt child. Now, the context being that right to adopt child, this is what the Delhi High Court recently ruled, that right to adopt a child cannot be considered a fundamental right under Article 21. This is a very, very important observation made by the Delhi High Court. The court clarified that prospective adoptive parents, that is the parents who plan to adopt a child, do not have the right to demand a child of their choice for adoption. So, the parents cannot demand that I want a child of this features, the face color should be this, the hair color should be this, and the height should be this. They cannot, demand such needs or requirement. Now, let us try to understand the background of the case, right? Now, see, the background of the case is several adoptive parents, right? Prospective adoptive parents, they approach the court after the adoption rules of 2022. These rules actually replace the adoption regulations of the year 70. So, the government framed rules in the year 2022 which replaced the adoption regulation of the year 2017. Which means these prospective adoptive parents, the PAPs, already had two biological children and sought to adopt a third child under the Juvenile Justice Care and Protection of Children Act 2015, which focuses on safeguarding child's welfare. However, the new rules of the year 2022 restricted such parents having two biological children from adopting a third child unless either of the two child is differently abled and has special needs or is a stepchild or relative. So the petitioners, they argued that the 2022 rules, right, these rules which replace these regulations, they are arbitrary, they are actually violating Article 14 of the Indian Constitution, and so it is unconstitutional. Why? Because this rules does not allow people having biological children to adopt a child unless the child is differently able. Now let us try to understand what the Delhi High Court, see, questions on right to marry the person of one's choice falls under which article? So right to adopt a child. Such questions can be asked in the examination. That's the reason we are discussing these topics. Now let us try to understand what the Delhi High Court ruled against the petitioner's argument in the Delhi High Court. First, on applying the rules retroactively. Now here, the court held that applying the new rules of 2022 to pending cases was valid. It held that the rules are constitutional and does not violate Article 14 of the Indian Constitution. The application of the rules was found to be fair and reasonable. This is one. Then on the right to adopt. Now on the right to adopt, the court stated that the right to adopt is not a fundamental right under Article 21 of the Indian Constitution. Therefore, the prospective adoptive parents cannot claim a legal right to adopt any child of their preference. You cannot recommend or suggest your preference when it comes to adopting a child. Then talking about the children's welfare, the court highlighted the fact that the primary purpose of adoption laws is to protect the, what is the purpose? The primary purpose is to protect the interest of the children. This is the primary purpose, not to fulfill the preference of those looking to adopt, or let's say the prospective adoptive parents. The system is designed to actually benefit the children who need families, particularly those who are very, very harder to please. So this is what the Delhi High Court ruled, and so it declared the rules of 2021 to be constitutional. Now, in this context, it is very important to understand what is CARA, that is Central Adoption Resource Authority. Now, please remember that CARA is statutory authority, which means it was established via law made in the Parliament of India, and this CARA falls under the Ministry of Women and Child Development. Again, a very, very important point for your prelims. It is the nodal agency, the point of contact for adoption of Indian children, and is responsible for regulating in country, within the country, and intra-country adoption. In country and within intra-country adoption. Now, CARA, it functions under the framework of the Hague Convention on Inter-Country Adoption 1993. India ratified this Hague Convention in the year 2023. Now, please remember CARA, it primarily handles the adoption of, let's say, orphaned children who are abandoned, and let's say the surrendered children. How? Through recognized adoption through CARA, that is Central Adoption Resource Authority. Now, when it comes to adoption, these are the eligibility regulations for adoption. Now, this again is self-explanatory. I want you to please go through these points by downloading the notes from the description box. So please open the link, make sure that you are downloading the PDF so that you can revise, you can read, go through these points. Again, you don't have to mug it up, you just have to go through it, and don't worry, you'll be in a position to recall all the points in case a question has been asked on this topic. This brings us to the last topic of the day, the 10th topic of the day, which is on the overseas citizens of India. The Ministry of External Affairs recently clarified that there have been no changes made to the OCI rules. Now, this clarification comes and continued, or comes amidst the continued interest in the rights and obligations. So, which are the rights and obligations of the people who are having the OCI, that is the overseas citizens of India. This is the context. I know you have not understood the context, but don't worry, we'll understand first what is OCI. Okay. See, questions on citizenship are often asked in the examination, so it is important to actually understand such topics as well. Now, what is the scheme Overseas Citizens of India? What does it mean? See, the Overseas Citizenship of India scheme was introduced through an amendment to the Citizenship Act of 1995. Now, this act is the principal act. This act is the principal act. I hope we all know the Citizenship Amendment Act of the year 2019, which actually led to a lot of issues, protests in the country, across our country. Right, when the global media captured the protests going on in our country. Why? Because many people from different organizations, different religions, they criticize the amendment made to this act in the year 2019. The provisions we discussed in yesterday's lecture, so make sure that you are going through the provisions of the Citizenship Amendment Act of the year 2019, the cutoff date, people belonging to which religions, which countries, very important to know. So this was introduced, how? An amendment was made to the Principal Act of 1955. So the OCI scheme, it allows for the registration of persons of Indian origin as overseas citizens, providing them with certain privileges without granting full Indian citizenship. Which means if people of Indian origin who are connected to India, let's say through their parents, grandparents, They're not Indian citizens. Please remember this point. They're not Indian citizens, but they're linked to India through their parents. They are referred to as overseas citizens of India, and they are extended certain privileges. So please remember that the OCS status is not equivalent to dual citizenship. Very important point for you prelims. It is not equivalent to dual citizenship, because dual citizenship is not allowed in our country. And the OCI, it does not permit dual citizenship, and the OCI card grants limited rights primarily related to residence and travel. So only when it comes to residency and travel, the OCI card holders get certain benefits. Can be granted to PI, that is person of Indian origin, who are the citizens of India on or after Jan 26, 1950, were eligible to become Indian citizens on Jan 26. Jan 26 is the date when the Indian Constitution came into effect, was brought into force. I hope you understood what exactly one understands by OCI, which means to explain simply, people who are connected to India through their parents or grandparents. As they're connected to India, so the Indian government decided to grant certain benefits when it comes to, let's say, residence or travel. So people who are, or let's say, have never been citizens of Pakistan or Bangladesh or any of the countries specified by the central government are not eligible for OCA, because the people of the enemy nations are not eligible for the OCI status. Why? Because of the national security concerns. For example, there may be thousands and lakhs of people in Pakistan and Bangladesh who may be related to India, the land India encompasses through their parents or grandparents. But as these countries are declared enemy by a country, of course not Bangladesh, Pakistan for sure. So these people from these nations are not eligible for OCI status. Now, which are the eligibility criteria for OCI card? Again, this is explanatory, self-explanatory. So I please request you to quickly go through these points, or go through these points through the downloaded, through the PDF that is available in the description. The PDF is not available, the link is available. So make sure you are clicking on the link and downloading the PDF. Now again, these points are very, very important. They are asked in the examination. OCI card holder is not entitled to 1. Dual citizenship or political rights. Dual citizenship not permitted. Second, voting rights or membership in the Legislative Assembly, which means people who have the OCI card, they cannot apply for double citizenship because Indian Constitution does not allow. Second, they cannot vote in the parliament elections, state assembly elections. Third, holding Indian constitutional posts like the president, vice president, judge of the Supreme Court or High Court. They are not entitled to people holding this position. They are not entitled to the government and government employment. These are the terms again you can. So the protected area permit, the point that we discussed under the inner line permit, the first topic that we discussed today, right? So please quickly go through these points. And these are the grounds for cancellation. Let's say, for example, if the registration was obtained through fraudulent means, through fake documents, then the OCS status can also be snatched away, can also be terminated. So these are some points that you can quickly go through. And which are the benefits? Benefits: multiple entry, multi-purpose, lifelong visa. You don't have to request for a visa every single time. You get multiple entry and multi-purpose visa. Exemption from registration with the foreigners regional registration officer for any length of stay in India, which means you can travel India any number of times. There is no restriction, right? And then how are they equal with the non-resident Indians, the NRIs? One, economic and financial investment. They are free to make investments in our country. Education, they can also get admissions in our colleges, schools, colleges. But please remember, the OCI card holders are not entitled to purchase agricultural land or plantation property. So this point is actually very important for your prelims point of view. So please make sure that you remember this point. So finally, this brings us to the end of the 10th topic. I hope students you understood each and every topic and understood the importance of these topics from the prelims point of view. Now, after explaining all these topics in great depth and in great simplicity, I expect you to please revise these points so that you do not miss any marks if questions are asked from these 10 topics. So students, make sure that you open the link mentioned in the description, download the copy, go through it, revise it, and be fully prepared for the examination. If you have any questions, any doubts, I request you to feel free to ask in the comment section. On this note, I call it a wrap. Thank you so much for watching, and before you close the video, I request you to please hit the like, subscribe, and also share the video as much as possible so that other students also benefit out of this program. Thank you so much for watching.